Alrighty, party peoples of the interwebs, a Texas judge appears to have ratified fraud by Big Pharma under the PrEP Act. I'll explain in this vlog. Viva Frei, former Montreal litigator turned current Florida rumbler, and I am quite clearly not in Florida, although I do look forward to getting back to the nice, green, warm lushness of the free state of Florida, up in Quebec and Canada. But there is news coming out of Texas. A judge who is an octogenarian judge, not that it changes anything, appears to have just ratified fraud by Big Pharma under the PrEP Act. Now, for those of you who might not know, the Attorney General of the state of Texas, Ken Paxton, recently sued Pfizer for fraud and various other violations under the law. I said at the time, it's a great lawsuit. He picked a seemingly good jurisdiction. That lawsuit was tossed. But before we get into the tossing of that lawsuit, let's get into the nature of that lawsuit.
In your headlines this morning, State Attorney General Ken Paxton is now suing the pharmaceutical company Pfizer, saying that their vaccine didn't end the pandemic.
No, Paxton's office is accusing the drug maker of misrepresenting the vaccine's effectiveness and trying to, quote, censor public discussion of the product. Paxton says Pfizer's claim its vaccine is 95% effective against the virus was highly misleading. In a statement, Pfizer says the lawsuit has no merit.
From the office of the Texas Attorney General, Ken Paxton, Attorney General of Texas. Attorney General Ken Paxton sues Pfizer for misrepresenting COVID-19 vaccine efficacy and conspiring to censor public discourse. Texas Attorney General Ken Paxton sued Pfizer Inc. for unlawfully misrepresenting the effectiveness of the company's COVID-19 vaccine and attempting to censor public discussion of the product. Pfizer engaged in false, deceptive, and misleading acts and practices by making unsupported claims regarding the company's COVID-19 vaccine in violation of the Texas Deceptive Trade Practices Act. So the legal basis of this lawsuit was very interesting. It's based on the Deceptive Practices Act, and very interesting to note as well is that they are alleging, or at least the Attorney General was claiming, that false claims were made, misrepresentations were made, also known as fraud, and in law, fraud vitiates everything, apparently, except for fraud when it comes to the PrEP Act. Later on in the press release, the pharmaceutical company's widespread representation that its vaccine possessed 95% efficacy against infection was highly misleading. That metric represented a calculation of the so-called, quote, relative risk reduction, end quote, for vaccinated individuals in Pfizer's initial 2-month clinical trial results. FDA publications indicate, quote, relative risk reduction, end quote, is a misleading statistic that, quote, unduly influences, end quote, consumer choice. Pfizer was also put on notice at that time that vaccine protection could not accurately be predicted beyond 2 months. Nevertheless, Pfizer fostered a misleading impression that vaccine protection was durable and withheld from the public information that undermined its claims about the duration of protection. And despite the fact that its initial clinical trial failed to measure whether the vaccine protects against transmission, Pfizer embarked on a campaign to intimidate the public into getting the vaccine as a necessary measure to protect their loved ones. And if you had any doubts about the statements made by Pfizer and its CEO, Albert Bourla, I refer you only to one of Albert Bourla's April 1st, 2021 tweets, and no, it wasn't an April Fool's joke.
And to be totally accurate, I will read it in Albert Bourla's voice. Albert Bourla, at Albert Bourla, excited to share that updated analysis from our phase 3 study with BioNTech also showed that our COVID-19 vaccine was 100% effective in preventing hashtag COVID-19 cases in South Africa. 100%. April 1st, 2021 at 9:46 a.m.
The mRNA was the technology that we had less experience, only 2 years working on this. And actually, mRNA was a technology that never delivered a single product until that day. Not vaccine, not any other medicine. So it was very counterintuitive, and I was surprised when they suggested to me that this is the way to go. And I questioned it, and I asked them to justify, how can you say something like that? But they came and they were very, very convinced that this is the right way to go. They felt that the 2 years of work on mRNA since 2018, together with BioNTech, to develop a flu vaccine, made them believe that the technology is mature and we are at the cusp of delivering a product. So they convinced me. I follow my instinct that they know what they are saying. They're very good. And we made this very difficult decision at that time.
So yeah, Ken Paxton is not just alleging that Pfizer tried its best, disclosed the necessary information, but failed to provide what it was contractually obligated to provide. They are alleging that Pfizer lied and people died, and a judge just basically said, yeah, no problem. They get immunity under the PrEP Act. Actually, before we get to the judgment, because it's a short two-pager dismissing Texas's lawsuit, let's just get to the final statements of Attorney General Ken Paxton. Quote, "We are pursuing justice for the people of Texas, many of whom were coerced by tyrannical vaccine mandates to take a defective product sold by lies," end quote, said Attorney General Paxton. Quote, "The facts are clear. Pfizer did not tell the truth about their COVID-19 vaccines, whereas the Biden administration weaponized the pandemic to force illegal public health decrees on the public and enrich pharmaceutical companies. I will use every tool I have to protect our citizens who were misled and harmed by Pfizer's actions," end quote. The lawsuit follows Attorney General Paxton's investigation into Pfizer and other vaccine manufacturers announced earlier this year. For those of us that have been paying attention, at least for the last 4 years, none of this comes as any surprise. We know Pfizer lied. We had that British woman saying how Pfizer never even tested for transmission because they were moving at the speed of science, and Texas sued.
Regarding the question around, did we know about stopping immunization before it's entered the market? No. We had to really move at the speed of science to really understand what is taking place in the market. And from that point of view, we had to do everything at risk.
And now Texas had their lawsuit dismissed by a geriatric octogenarian who probably felt personally at risk in the context of this entire discussion, so probably is not the best, least biased judge to render this decision. But yeah, this judge, who was he appointed by? Ronald Reagan, people.
But she's an old lady. I mean, look at her. She's old. You can't just take her stuff. She's too old.
Samuel Ray Cummings. Overview. Samuel Ray Cummings is a senior United States District Judge of the United States District Court for the Northern District of Texas. Born October 18, 1944. Age 80 years. Lubbock, Texas, United States. Appointed by Ronald Reagan. And what does the octogenarian Judge Cummings say about all of this? A man who probably felt very protected by these mandates, who probably felt very vulnerable by COVID. He says in a two-page decision, immunity under the PrEP Act. Immunity from fraud, people. In the United States District Court for the Northern District of Texas, Lubbock Division, State of Texas plaintiff versus Pfizer Inc. defendant. On this date, the court considered defendant's Rule 12b-6 motion to dismiss plaintiff's complaint, along with the briefs in support. The court further considered plaintiff's opposition to the motion to dismiss, along with defendant's reply. Finally, the court considered the supplemental authority filed by defendant. The court need not repeat the issues and facts presented in light of the parties' extensive and thorough briefing on the same. The issues relevant to the motion to dismiss turn on questions of law that can be decided on the pleadings. After careful consideration of the arguments, applicable law, and circumstances presented, the court finds that the motion to dismiss is granted. So just to explain what happens here, the judge comes out and says, yeah, all of the questions being presented to me right now are questions of law that I, as judge, am empowered to decide upon. I've read all of your pleadings. I've read everything about this file. We don't need to get into any of it in further detail for me to motivate this decision to dismiss the lawsuit. I am granting the dismissal of the lawsuit as filed by the defendant, Pfizer Inc. More specifically, the court finds that as a matter of law under the circumstances of this case, the defendant is entitled to immunity under the Public Readiness and Emergency Act, the PrEP Act. Moreover, both the PrEP Act and the Food, Drug, and Cosmetic Act, the FDCA, preempts plaintiff's claims. Finally, the court finds that the alleged statements by defendant were not connected to any, quote, trade or commerce, end quote, or any, quote, consumer transaction, end quote. Thus, plaintiff's claims against defendant are hereby dismissed for essentially the reasons argued in the motion and reply. So ordered, dated this 30th day of December 2024, Sam R. Cummings, Senior United States District Judge. Interesting distinction of law here. People often ask me, how is it that Dan Hartman, the father of Sean Hartman, who died 33 days after taking the Pfizer jab up in Canada, is able to sue Pfizer? How is it that Kayla Pollack is able to sue Moderna? She was rendered a quadriplegic after a Moderna booster after 2 Pfizer shots. People ask me, how can they sue in Canada? Are the pharmaceutical companies not immune from lawsuit in Canada? And the answer is no, they are not immune from lawsuit in Canada. The PrEP Act in the United States granted legislative immunity to the pharmaceutical companies to prepare their wonderful products, whereas up in Canada, there was no legislative immunity, but there is contractual immunity in that the contracts, the supply agreements between the pharma companies and the government contain a hold harmless clause so that if they do get sued and any judgment is rendered against them under the hold harmless provisions of their contract, the government in theory would have to indemnify the pharmaceutical companies for any amount they are ordered to pay the plaintiffs, which might be the case in the Kayla Pollack and Dan Hartman lawsuit. We'll see where those go. And something tells me that the government might start invoking fraud if, in fact, they are ordered to hold harmless the pharma companies, if, in fact, the pharma companies did, in fact, fraudulently induce people to taking that jab, if they did fraudulently misrepresent their results, which we know that they did. So the government does have a backdoor to get out of any hold harmless clause if it turns out that the party that they agreed to hold harmless lied to them, withheld information from them, and fraudulently induced them into signing those supply agreements in the first place, but now moving back to America. The PrEP Act offers legislative immunity to these pharma companies, which in theory would cover any immunity from them carrying out their functions properly and honestly, but it should not cover fraudulent acts committed by the pharma companies. But this judge says, yeah, I've heard all of the arguments, and I don't want to get into it. Pharma immunity under the PrEP Act. Now, I suspect this goes to appeal, and I hope to goodness this goes to appeal because this decision needs to go to appeal. The pharma companies need to be held to account. They committed fraud. Fraud vitiates everything. I don't care if they have legislative immunity. Had they done what they were allowed to do under the law, they lied, and therefore they can't claim immunity under the PrEP Act. We will see, but before I forget, have you taken 3 seconds to go down there, make sure that you are subscribed and have notifications turned on? Please do it. It takes 3 seconds. It's free and it helps the channel grow. Also, and obviously more importantly, Kayla Pollock, if you don't know her, go back and check out my interview with her. She in Canada is forced to raise money for her own existence. After she was rendered a quadriplegic, the government of Canada offered her maids, medical assistance in dying, not once, not twice, but thrice. Unsolicited, said to Kayla Pollock, you're never going to get any better. We can't treat you for what you've gotten now. As a result of our mandates, our policy, we offer you death instead. And so Kayla Pollock is forced to crowdfund for her own existence in order to pay for rehab and all other medical issues that she's facing. I'll put a link to her donate page in the pinned comment below. Go check it out. Donate if you can, and if you can't, at least just spread the word. But that is the news of the day. Pfizer immunity for its own alleged fraudulent misrepresentations, at least according to this judge. And I hope to goodness it goes to appeal and this judge gets spanked on appeal. We will see. Most importantly, December 31st, Happy New Year in advance to everybody. Nothing but good things in 2025. Health and happiness. And what's going on with this car? The car's wheel is moving. All right, well, that is a time to end the vlog. Thank you for tuning in. Now you know your vlog. Peace out, people. Booyah.
Did we know about stopping immunisation before it's entered the market? No.
Right to jail, right away.